Quick disclosure, this is an AI-voiced episode of the Syndicate Room, produced by AdValorem for education and research, not advice.
And if you've ever thought legal stuff is a distraction, today might change your mind.
That's the risk, not price risk, enforcement risk. In alternative assets, enforcement risk is the hidden tax that makes returns look random.
But the real world is messy. Missed notices, dissolved entities, abandoned obligations, and a lot of "we'll get to it later."
Here's the fear. If you don't understand what the courtroom process looks like, you'll either over-discount a legitimate claim, or you'll underprice the time, friction, and sequencing required to make it real.
And that's how smart people end up doing the dumbest thing. They pretend the claim doesn't exist because the path to collect feels unknowable. Let me say this again, slowly. A warrant is not equity. It's an equity claim with a time-sequenced enforcement path. If you model it like public stock, you'll miss the point. The moment filings become imminent, the asset stops being a story and starts becoming a process. Our research desk published a piece on this called "The Warrants Are Going to Court. Here's What Happens When They Do." Link in the show notes. And this episode sits inside a 3-pillar research arc we laid out in a long-form overview on Substack, also in the show notes. This is Pillar 1 of 3, warrant enforcement and severed case recovery, using the Newchip 218 plus warrant portfolio as research context, not as a pitch.
Here's the 4-step playbook, and I'm going to number it because this only works if you can repeat it. Right. Step 1. Inventory the claim. What do you actually have? A warrant, a contract right, a notice obligation, a payment covenant? Get the documents, the dates, and the triggers. If you can't point to the trigger, you don't have a thesis. You have a hope.
Step 2. Map the defendants and the venues. The company might be dissolved, merged, or renamed, but obligations can survive in surprising ways.
Court timelines, response windows, discovery, settlement posture. This is the cap table math of enforcement.
And here is the big one. Statute of limitations tolling can turn late into still live. Step 4. Translate damages into a simple model.
Past due interest, opportunity loss damages, the investor base that should have been there. You don't need a perfect number. You need a range with assumptions you can defend. Historical parallel. Early venture returns weren't missing because companies were bad. They were missing because the infrastructure to realize returns didn't exist yet. Custody, transfers, enforcement, standard terms. The plumbing came later.
That loops us back. Warrants do not die because they are always worthless. They die because the enforcement layer is underbuilt. When filings are imminent, you are watching infrastructure get built in real time, in a courtroom. If you want the ongoing research we publish daily at gp.advalorem.io, explainers, frameworks, and primary source reading lists. Join the conversation in Discord at discord.gg/GERGTP9GTS. And the structured community application is tidycow.com/advalorem/syndicate.
Quick teaser. Thursday is Pillar 2, Frontier Deep Tech and Pre-IPO Allocation, using SpaceX as the canonical case. Next Monday is Pillar 3, AI Sovereignty and the Build-It-Yourself Stack. Your job isn't to predict the future, it's to build a portfolio that survives the path there. Position before you predict. If this episode helped, send it to one operator turned investor who still thinks enforcement is someone else's problem.